How do trusts handle stepchildren? Have you ever wondered how trusts can be used to include stepchildren in estate planning? This is an important topic for blended families. Trusts can play a vital role in ensuring that stepchildren are taken care of in the event of a parent's passing. Unlike biological or legally adopted children, stepchildren usually do not have automatic rights to inherit under state laws. This means that if you want to provide for your stepchildren, it is essential to specifically include them in your estate documents. One of the main advantages of using a trust is the ability to explicitly name stepchildren as beneficiaries. This avoids any confusion that might arise from general terms like children, which courts may interpret as only referring to biological or adopted offspring. By clearly identifying stepchildren in the trust, you ensure that they receive their intended inheritance. Another benefit of trusts is the control they offer over how and when assets are distributed. You can set specific conditions for distributions, such as staggered payments over time or milestones that must be met. This can help protect the inheritance from being spent too quickly or mismanaged. Trusts also provide privacy. Unlike wills, which go through probate and become public documents, trusts remain private. This can help reduce potential family conflicts between biological children and stepchildren, making the process smoother for everyone involved. Additionally, trusts can include provisions that protect assets from creditors or from beneficiaries who might not manage their funds responsibly. This is especially important in blended families where financial management can vary among family members. When creating a trust for a blended family, it is essential to balance the interests of both biological children and stepchildren. This can be done by structuring the trust to provide for both groups, either through separate trusts or by allocating shares within a single trust. This approach helps respect the rights and expectations of all parties involved. If there are minor stepchildren, estate planning should also consider guardianship. Naming guardians in your estate plan is crucial, especially if biological parents are deceased or unavailable. This ensures a smooth transition of care for the children. To effectively handle stepchildren in trusts, here are some practical steps to follow. First, clearly name stepchildren in the trust documents. Avoid using vague terms to prevent any misunderstandings. Second, update your estate documents regularly to reflect any changes in family dynamics. Third, communicate your intentions with family members to minimize potential disputes. Lastly, consider legal adoption if appropriate. This can grant stepchildren the same inheritance rights as biological children, simplifying the estate distribution process. In summary, trusts provide a flexible and controlled way to include stepchildren in estate plans. They help ensure that stepchildren receive the benefits intended for them while balancing the needs of biological children and minimizing legal conflicts. Proper drafting and clear language are key to achieving these goals effectively.